My Lords, if it may please the Court, I'm Andrew Parker and my learned friend is Emily Green. We appear on behalf of Shazam Cars, the appellant in this case. There are two broad submissions we'd like to make. The first based on the proposition that causation in economic tort is to be distinguished from that in breach of contract. The authority to be applied is Lumley and Guy, 1854. We submit that by holding that the respondents' actions were insufficiently causative of their father's breach of contract, that the Court of Appeal has misconstrued the nature of liability in economic tort. We submit and argue that this is a very different species of liability.
The second submission is that there can be no breach without the inducement. OBG and Allen is clear that there is a parallel between inducing breach of contract and circumstances in which the defendant becomes liable as an accessory to the breach of contract of another. There are three main causative points. The fact that a breach of contract and economic harm was inevitable is evidence the respondents intended or were indifferent to the economic harm. A deliberate choice had been made to act in full knowledge of the consequences, and but for their acceptance of their father's assistance, the breach would not have occurred. It was therefore a wholly causative and necessary precursor to the breach of contract, and the appeal should be upheld on those grounds.
Yeah, it's all right. I think I might have missed out.